Legal and Privacy Brief for April 30, 2026. The Supreme Court struck down Louisiana's congressional map for racial gerrymandering while hearing critical arguments on geofence surveillance and temporary protected status. Maryland became the first state to ban surveillance pricing in grocery stores. The House renewed Section 702 warrantless surveillance powers for 3 years. Here's the full breakdown of today's top legal and privacy stories. Legal and Privacy Brief April 30, 2026. Next section, Enforcement Actions. European Commission charges Meta with child safety violations. The European Commission formally accused Meta of violating the Digital Services Act by failing to prevent children under 13 from accessing Instagram and Facebook. The Commission found that Meta relies solely on self-declared age with no verification mechanism and does not adequately identify or remove underage users. Evidence across the EU shows 10–12% of children under 13 are using these platforms. Meta contradicted its own statements in the inquiry by claiming enforcement was adequate despite readily available scientific evidence showing younger children face heightened vulnerability to platform harms. Meta could face fines up to 6% of annual revenue plus periodic penalty payments to force compliance. Compliance action: review age verification mechanisms for any platforms serving EU users. Document risk assessments for minors accessing services. Implement proactive detection and removal systems rather than relying on self-declaration. Sources: The Record. DOJ, the Department of Justice. China coordinate on Dubai Scam Center raids. The Justice Department announced charges against 4 individuals running pig butchering scam centers in Dubai following coordinated raids with Chinese authorities that led to 276 arrests. Federal prosecutors charged Thet Min Ni, Burmese national, and Indonesian nationals William Awang, Andreas Chandra, and Lisa Merriam with fraud and money laundering. The defendants allegedly ran front companies Co-Thet Company, Sanyo Group, and Giant Company to conduct cryptocurrency investment scams that defrauded U.S. victims of millions. The coordination with Chinese law enforcement represents a shift in international cooperation on cybercrime enforcement. Though the DOJ did not address the status of the 276 people arrested or the human trafficking conditions typically present in these facilities. Compliance action: review cryptocurrency transaction monitoring systems. Train finance teams to identify pig butchering scheme red flags. Report suspicious investment scheme communications to the FBI Internet Crime Complaint Center. Sources: The Record. Swiss police arrest Black Axe regional leader. Swiss and German authorities arrested 10 suspected members of the Nigerian criminal network Black Axe, including a regional leader overseeing Southern Europe operations. The suspects, aged 32–54, face charges for romance scams causing millions in losses and international money laundering. Europol estimates Black Axe has 30,000 registered members worldwide, organized into 60 zones in Nigeria and 35 abroad, generating billions annually through cybercrime, drug trafficking, and human trafficking. The arrests follow a 2023 international crackdown that seized over 200 bank accounts and a 2026 Spanish operation detaining 34 members. Compliance action: strengthen customer due diligence for international wire transfers. Flag romance scam indicators in fraud monitoring systems. Review anti-money laundering controls for Nigerian origin transactions. Sources: The Record. Next section, Litigation Updates. Supreme Court strikes down Louisiana redistricting map. Louisiana v. Calais. The Supreme Court ruled 6-3 that Louisiana's 2024 congressional map, creating a second majority Black district, violated the Constitution's Equal Protection Clause through unconstitutional racial gerrymandering. Justice Alito's majority opinion held that no compelling interest justified the state's use of race in redistricting, even when attempting to comply with Section 2 of the Voting Rights Act. Justice Kagan's 14-minute dissent argued the decision completes this court's effort to dismantle, and indeed, destroy the Voting Rights Act, rendering Section 2 protections all but a dead letter. The map had created a second majority Black district following a lower court ruling that the prior 2022 map, with one majority Black district for a state with 1/3 Black population, likely violated the VRA. The decision leaves Louisiana barred from using the 2024 map in future elections while preserving the current Congress member elected under it. Compliance action: review any redistricting processes for constitutional compliance. Consult counsel before using race as a factor in electoral boundary decisions. Document non-racial rationales for any district changes. Sources: Scadu S. blog. Fourth Circuit blocks ERISA mandatory class certification. Trauernicht v. Genworth Financial. The Fourth Circuit reversed a district court certification of a mandatory class under Rule 23b1 in an ERISA fiduciary breach case involving a defined contribution plan. The court held that ERISA Section 502(a)(2) claims seeking monetary relief for alleged fiduciary breaches in defined contribution plans cannot be certified as mandatory classes because they are individual monetary damages claims, not derivative plan-wide relief. The court rejected the district court's reasoning that ERISA fiduciary duty claims inherently satisfy Rule 23's commonality requirement, emphasizing that commonality requires proof that class members suffered the same injury capable of resolution in one stroke. The ruling stressed that in defined contribution plans, assets are held in individual accounts and participants may be affected differently by alleged breaches depending on investment timing and withdrawal dates. Compliance action: review pending ERISA litigation strategies for defined contribution plans. Oppose mandatory class certification in 401k fiduciary breach cases using this precedent. Document individualized participant account impacts in breach assessments. Sources: inside class actions. CSC Service Works Data Breach Settlement. Available: a class action settlement is now open for consumers whose information was compromised in the 2024 CSC Service Works data breach. CSC Service Works operates laundry payment systems in apartment buildings and laundromats. Settlement details, including compensation amounts and claim deadlines, were not disclosed in the public notice. Compliance action: notify affected employees or customers if your organization contracted with CSC Service Works. Provide settlement claim information to potentially eligible individuals. Source: top class actions. Hims and Hers face dual data breach class actions. 2 class action lawsuits accuse telehealth companies Hims and Hers of failing to adequately protect patient information in data breaches that exposed consumers to identity theft and fraud. The complaints allege inadequate security controls for sensitive medical and personal information. The lawsuits follow a pattern of healthcare data breach litigation targeting telehealth platforms that store prescription records, payment information, and health conditions. Compliance action: audit encryption and access controls for telehealth patient data. Review HIPAA, the Health Insurance Portability and Accountability Act, security rule compliance for cloud-stored health information. Document breach notification procedures and incident response plans. Source: top class actions. By Heart Infant Formula litigation, consolidated in MDL, the Judicial Panel on Multidistrict Litigation, consolidated 19 class action lawsuits against infant formula manufacturer, By Heart, into a new MDL in New York federal court. The consolidation will streamline discovery and pretrial proceedings. MDL assignment typically indicates significant common factual questions across multiple cases filed in different jurisdictions. Source: top class actions. Next section: regulatory guidance. House renews Section 702 Surveillance Authority. For 3 years, the House voted 235-191 to renew Section 702 of the Foreign Intelligence Surveillance Act, allowing warrantless surveillance of foreigners for 3 years. The bill now heads to the Senate one day before the authority expires. GOP leaders added Fourth Amendment safeguards and tougher penalties for privacy violations to win conservative support, but the final bill contains no warrant requirement for querying Americans' messages. Permanent ban on Federal Reserve digital currency was attached to secure ultra-right conservative votes, leading Senate GOP leaders to indicate they will not support the House version. The Senate may pass its own renewal and send it back to the House hours before the deadline. Compliance action: monitor final passage outcome for surveillance compliance obligations. Review procedures for government data requests under Section 702. Document separate handling for U.S. person data versus foreign data. Sources: the record. Ninth Circuit upholds federal officer mask ban block. The Ninth Circuit upheld a lower court ruling blocking California's law banning federal immigration officers from wearing masks during enforcement operations. The appeals court held that the No Vigilantes Act Section 10 directly regulates the United States in its performance of governmental functions, violating the Supremacy Clause. The district court had blocked the mask ban while allowing an ID display requirement to stand, ruling the mask ban discriminated against the federal government because it exempted state troopers. The Ninth Circuit rejected California's argument that the law could survive by applying to all law enforcement officers, stating the correct standard applies to direct regulation of governmental activities. The court did not address public safety concerns raised by the FBI regarding masked criminals posing as law enforcement officers. Compliance action: businesses operating in California should continue following federal law enforcement requests regardless of state mask restrictions. Document all federal officer interactions, including presence of identification. Source, TechDirt. Epic challenges GLBA amendment draft. Epic, the National Consumer Law Center, UNIDOS US, and 42 civil society organizations sent a letter to the House Financial Services Committee opposing a draft bill to amend the Gramm-Leach-Bliley Act. The coalition argues the discussion draft expands GLBA an effective notice and choice framework, includes a weak data minimization standard, lacks a private right of action, and would preempt stronger state financial privacy provisions. Epic submitted a separate statement for the record to the committee's March 17 hearing on financial privacy frameworks. Compliance action: track the GLBA amendment draft through committee. Review current GLBA compliance programs for potential changes. Engage with state-level financial privacy protections that may face preemption. Source, Epic News. Next section, privacy developments. Maryland bans surveillance pricing in grocery stores. Maryland became the first state to ban surveillance pricing in grocery stores, prohibiting retailers from using personal data to set varying prices for different buyers. The law follows an FTC, the Federal Trade Commission, investigation and report published in January showing companies use expansive personal data ranges in dynamic pricing. Anti-surveillance advocates noted the law contains industry carve-outs that may allow companies to achieve similar outcomes through harder-to-detect methods. Colorado, California, Massachusetts, Illinois, and New Jersey are considering similar bills. Epic counsel Tom McBrien said the exemptions allow other ways of arriving at the same outcome that are just harder for consumers to detect. Compliance action: audit dynamic pricing systems for use of personal consumer data. Review Maryland retail operations for surveillance pricing compliance. Document pricing algorithms and data inputs to demonstrate non-discriminatory pricing. Source, Epic News. Supreme Court hears geofence warrant case, Chatri v. United States. The Supreme Court heard arguments on whether geofence warrants violate the Fourth Amendment by allowing police to request location data from Google and other providers to identify all devices in a geographic area during a specific time period. Epic Executive Director Alan Butler argued in a statement that geofence searches are an incredibly invasive investigative technique that threatens the Fourth Amendment rights of hundreds of millions of individuals. The court should hold that the Constitution protects digital data stored by app or cloud providers and ensure highly sensitive phone-generated records cannot be obtained without particularized suspicion and close judicial oversight. Google has since transferred location data from its servers to individual phones, preventing the company from complying with geofence warrants in the same way, though the government is increasingly seeking data directly from cell phone providers and other companies. Compliance action: review law enforcement data request procedures for location data. Implement particularized suspicion requirements for geofence requests. Document Fourth Amendment analysis for bulk location data disclosure. Sources, Epic News. Epic News. Epic News. Epic challenges illegal save system overhaul. League of Women Voters v. DHS. Epic and the League of Women Voters renewed their call for a federal court to block DHS's conversion of the SAVE system, systematic alien verification for entitlements, into an illegal mass voter verification and benefits eligibility tool. The plaintiff's combined reply and opposition brief argues DHS has subjected members to widespread privacy violations, false identification as potential non-citizen voters, forced citizenship proof demands, voter roll purges, and disenfranchisement. The brief highlighted a recent executive order directing DHS and SSA to create state citizenship lists of every voting-age American citizen. The case is part of Epic's broader effort to fight the administration's illegal collection of state voter information and attempted creation of national databanks. Compliance action: do not provide state voter roll data to federal requests without court order. Document legal basis for any citizenship verification data sharing. Challenge overly broad federal data demands through counsel. Source, Epic News. Epic testifies for Vermont privacy expansion. Epic Deputy Director Catriona Fitzgerald testified before the Vermont House Committee on Commerce and Economic Development supporting S. 71 v. 2-3, which would expand consumer data privacy protections. The bill includes strong data minimization provisions, heightened minor protections, and a ban on sensitive data sales. Epic noted the removal of the private right of action, present in last session's vetoed version, was a significant concession, but still supports the legislation. Fitzgerald testified that privacy is a fundamental right, and it is time for business practices to reflect that reality, as self-regulation has failed and Congress remains unable to enact comprehensive protections. Compliance action: monitor Vermont privacy bill passage. Prepare compliance program for data minimization requirements and sensitive data sale prohibitions. Review minor data handling procedures for enhanced protections. Source, Epic News. Texas license plate reader expansion faces pushback. Texas municipalities are pushing back against rapid adoption of flock automated license plate reader systems as privacy advocates highlight the unregulated nature of the technology. Epic fellow Cabaz Ajar told the Texas Observer that the use of flock currently is completely unregulated, and even when regulations exist, the system operates on the honor system with no meaningful oversight. The cameras capture location data on vehicles and store it for extended periods, creating mass surveillance databases accessible to law enforcement. Compliance action: review parking lot and property surveillance systems for license plate data retention policies. Document legitimate business purposes for any automated plate recognition. Limit law enforcement access to warrant-based requests. Source: Epic News. GAO report reveals Doge Treasury access security failures. A GAO report found the Treasury Department flouted basic security safeguards when granting the Department of Government Efficiency access to sensitive payment systems. Epic Deputy Director John Davison said Treasury concluded one Doge employee would be in a position to cause inestimable damage to security interests, but failed to obtain a signed access agreement or comply with baseline safeguards. The employee subsequently broke the law by disclosing sensitive, unencrypted personal data related to UZ operations. Compliance action: review third-party access controls to financial and payment systems. Require signed access agreements before granting sensitive system privileges. Audit compliance with baseline security safeguards for external government access. Source: Epic News. Next section: policy changes. Supreme Court considers temporary protected status termination. Mullen v. Doe. The Supreme Court heard arguments on whether the Trump administration properly terminated temporary protected status designations for Haitian and Syrian nationals. Then Secretary Kristi Noem ended both designations in 2025, stating Syria's new government was moving towards stable governance and finding no extraordinary and temporary conditions in Haiti preventing safe return. Noem also stated continuation would be contrary to the national interest. Federal judges in Washington and New York blocked the terminations. Solicitor General D. John Sauer argued courts cannot review DHS determinations on TPS designation or termination. UCLA professor Ahilan Arulanantham countered that DHS must turn square corners and follow statutory procedures. Justice Amy Coney Barrett's personal connection to Haiti: she adopted 2 children from there, including after the 2010 earthquake that led to Haiti's TPS designation, drew media attention as potentially relevant to her approach. Sources: Scotto S. Blog. Scotto S. Blog. DOJ indicts James Comey for Seychelles Instagram post. The Department of Justice charged former FBI Director James Comey with 2 federal felonies, threatening the president under 18 U.S.C. Section 871 and transmitting a threat in interstate commerce under 18 U.S.C. Section 875C for posting an Instagram photo of seashells arranged to spell 8,647 with the caption "Cool shell formation on my beach walk." First Amendment attorney Ken White called the charge preposterous and stated no competent or honest prosecutor would bring it, representing a betrayal of the professional and ethical obligations of every U.S. Department of Justice attorney involved. The indictment was filed by W. Ellis Boyle, U.S. Attorney for the Eastern District of North Carolina, after a prior indictment was dismissed because it was filed by Lindsay Halligan, who was not legally appointed as a U.S. Attorney. Compliance action: document all business social media policies regarding political speech. Review employee speech protections under applicable employment law. Consult counsel before disciplining employees for protected expression. Source: TechDirt. ICE courthouse arrest policy remains unclear. 2 unnamed DHS officials told NBC News that ICE field offices received verbal instructions to no longer arrest individuals inside courthouses without judicial warrants and to stop entering homes without warrants. However, a DHS spokesperson immediately contradicted the statement, saying no change in policy, and "we will continue to arrest illegal aliens at immigration courts following their proceedings in compliance with the law." The conflicting statements follow DOJ court admissions that ICE officers committed illegal arrests by detaining migrants attending immigration hearings. The verbal-only nature of any policy change suggests DHS is avoiding creating a paper trail. Compliance action: businesses should not alter cooperation with federal law enforcement based on unclear policy statements. Document all ICE interactions at business locations. Require warrants before allowing property access. Source: TechDirt. Next section: compliance takeaways. Age verification systems. Implement proactive age verification for platforms serving EU users rather than relying on self-declaration. The European Commission's Meta enforcement signals heightened scrutiny of child safety controls, with fines up to 6% of revenue at stake. ERISA litigation defense. Use the Fourth Circuit's Trauernish decision to oppose mandatory class certification in defined contribution plan fiduciary breach cases. Document individualized participant impacts to demonstrate lack of commonality required for class treatment. Section 702, renewal. Monitor final Section 702, passage and implement warrant-free surveillance procedures for foreign targets while maintaining separate U.S. person data handling protocols. The 3-year renewal extends warrantless foreign surveillance powers through 2029. Geofence warrant challenges. Develop Fourth Amendment challenge procedures for geofence warrants requesting bulk location data without particularized suspicion. The Supreme Court's Chatry decision will set nationwide standards for government access to cloud-stored location records. State privacy compliance. Track Maryland's surveillance pricing ban, Vermont's Comprehensive Privacy Bill, S. 71 v. 2-3, and similar legislation in Colorado, California, Massachusetts, Illinois, and New Jersey. Audit dynamic pricing algorithms and prepare data minimization controls for expanding state requirements. That concludes today's Legal and Privacy Brief. From Carolina, Clear Tech. For informational purposes only, not legal advice.